In accordance with the rules, an initial administrative fee is due upon filing the claim. The balance of the fee is due within 60 days of filing or before the first hearing, whichever comes first. The case administrator will advise the arbitrators as to whether the appropriate fees have been made. If you have any doubt, contact the case administrator to clarify the facts. Now, let's suppose that a claim is amended in the course of a hearing. Well, of course, first, the arbitrator must give the opposing party the opportunity to respond. Under the rules, the arbitrators can amend a claim. If they agree to do that, then you should contact the case administrator so that an appropriate adjustment can be made in the fee.
Well, that fee dispute is really for the AAA, and if it isn't resolved, and I hope you resolve it, then you can make a motion to dismiss, and we will rule on that motion when the time comes.
Before claimant begins, we would like to request that the witnesses be excluded from the hearing room during the testimony of other witnesses.
What's the point of that? I object to the exclusion of any witnesses, especially my expert witness.
Generally, only parties to the dispute have a right to be present in the hearing room. Arbitration is meant to be private, and privacy matters. So when in doubt, you probably ought to exclude witnesses. On the other hand, arbitration really is informal, and there can be good reasons for having witnesses present. One thing is, if they're present, they'll be there and ready to testify when they are called. Exclusion is most called for when credibility is really an issue, and a witness to an event wants to be in the hearing room while some other witness testifies to the same event. So you really can't rule on an exclusion request until you know what witness it is directed to and why. Well, you know, there really isn't any reason to resolve this one now. We'll wait until it arises at the hearing in respect to a specific witness, and then we'll rule on it then.
Ms. Burgess, what did you hear at that time?
Well, Mr. Faberman was on the phone with Jeff Speed, you know, the baseball player. He called him on his private line. And I heard the conversation from Mr. Faberman's end. And they were talking about negotiating a new contract for the upcoming baseball season and how they were going to get more money.
Do you know if your firm represents any sports figures as agents?
No, Jeff Speed was one of Mr. Faberman's private clients, and Jeff told me that he called
Wait,
to
Mr.
set up an
Arbitrator, wait, I
appointment.
object. That is pure hearsay.
We have already established that the strict rules of evidence need not apply in arbitration. The issue here is relevance, not hearsay. The firm is claiming that Mr. Faberman had private clients in violation of the partnership agreement. Ms. Burgess' testimony, in my mind, is quite relevant on that point, and we should allow it.
The fact that testimony is hearsay goes to its weight, you know, how much store we'll put in it, as opposed to its admissibility, whether we'll hear it. So we will hear it. But please do keep in mind that hearsay on sensitive issues may not be too persuasive, and if you build your case on it, you might not get too far.
At this time, we offer into evidence a copy of the firm's tax return for the period immediately preceding Mr. Faberman's departure from the firm.
Excuse me. This is just a photocopy. Where's the original?
The original's with the IRS.
Well, how do I know these figures are accurate? Can you vouch for their
Excuse
accuracy?
me, Mr. Field, but...
No, I want an answer.